Welcome back to Organized, the business law breakdown. I'm your host, Professor Seth C. Oranburg, and today we're exploring our final and fascinating contract law concept, third-party beneficiaries. Let me start with a question. Imagine you're not part of a contract. You didn't sign it, you weren't involved in negotiating it, but somehow, can you get rights under it? Sounds unusual, right? Nothing to do with the rest of this class. Well, that's exactly why we're ending this series on the doctrine of third-party beneficiaries, because under most cases, contract law follows the rule of privity. Privity means that only the parties to a contract have rights or obligations under it. But third-party beneficiary law creates an exception. And there are ways in which someone who isn't part of the contract can enforce it, if the original parties intended to confer a benefit on them. In this episode, we'll dive into this unique doctrine and answer three legal questions. What makes someone an intended third-party beneficiary? How do courts distinguish between intended and incidental beneficiaries? And what factors do courts consider when deciding who can enforce a contract? We'll break it all down using real-world cases. And along the way, we'll explore how this doctrine impacts everything from government contracts to private commercial agreements. So, if you've ever wondered how someone outside a contract can still benefit from it, or even enforce it, you're in the right place. Stay tuned as we unravel the complexities of third-party beneficiaries and uncover why this often overlooked doctrine is so important for modern commerce. Before we dive into today's cases, let me take a moment to unpack the core ideas behind third-party beneficiaries. This doctrine does not come up every day, but when it does, it can completely change how a contract is interpreted and enforced. So let's start with basics. Generally, contracts are governed by the rule of privity. Privity means that only parties to the agreement, those who proverbially sign on the dotted line, have rights and obligations under that contract. But as with many of the rules in contract law, there are exceptions. The third-party beneficiary doctrine is one of the biggest exceptions when it comes to the rule of privity. It allows someone who isn't a party to a contract to enforce it, but only if the contracting parties intend to benefit that third party. The key word is intended. Courts won't let just anyone claim rights under a contract. They may have recourse under some other law, but contract law is intended through the law of enforceable promises. If no one made a promise to you, how does contract law apply? So this brings us to our crucial distinction: intended beneficiaries versus incidental beneficiaries. You see, an intended beneficiary is someone the contracting parties specifically intended to benefit. These beneficiaries can enforce the contract if and when the intent to benefit them is clear. In contrast, an incidental beneficiary might benefit from a contract, but only as a side effect. And for them, there's no enforceable right. At least that's the rough cut on the law of third-party beneficiaries. So, how do courts decide if someone's an intended or just an incidental beneficiary? The Restatement Second of Contracts gives us the common law framework. A third party is an intended beneficiary if recognizing their right to enforce the contract is necessary to effectuate the intent of the parties, and either the promise will satisfy an obligation the promisee owes to the beneficiary, or the promisee intends the performance as a gift to the beneficiary. I'm going to read that one more time because it's complicated and central. A third party is an intended beneficiary if recognizing their right to enforce the contract is necessary to effectuate the intent of the parties, and either the performance will satisfy an obligation the promisee owes to the beneficiary, or the promisee intends the performance as a gift to the beneficiary, which again sets up the distinction between two more types of beneficiaries. We're going to call them now creditor beneficiaries and donee beneficiaries. If you notice, that second part Part 2 of the rule from the restatement is disjunctive. There was an or. Either the promise satisfies an obligation or intended as a gift. And so that means there are two types of intended beneficiaries: creditor beneficiaries, who are owed, and donee beneficiaries, who are given gifts. A creditor beneficiary arises when the performance under a contract fulfills a pre-existing obligation to a third party. For example, if I owe you money and someone else promises to pay my debt, you're a creditor beneficiary. And if my promise to pay you has to do with that intention, you might be an intended creditor beneficiary. A donee beneficiary, on the other hand, is someone the promisee intends to benefit as a gift, which you might think of like a life insurance policy when the insured names a beneficiary to receive payout. In the case of life insurance, these beneficiaries are often named in the contract, and therefore there is an express intent for the life insurance to benefit them. Once again, a key factor in determining whether or not a third party can enforce a contract. So intent is such a key concept in the intended beneficiaries doctrine, whether for creditors or donees. So how do courts examine or determine intent? Well, they look at several factors. The language of the contract is paramount, and the circumstances surrounding the agreement are important. The relationship between the parties is relevant, and whether performance is rendered directly to the third party is also part of the equation. Finally, courts will look at whether the third party's benefit is central to the contract's purpose. Now, here's something important. A third party does not need to be explicitly named in the contract. I gave an example of an insurance contract where they were, but you don't need it. It's enough if the third party belongs to a class of people the contract is clearly intended to benefit. And this doctrine is significant because it shapes who can enforce promises and when. Understanding these concepts is crucial for drafting clear agreements, avoiding unintended obligations, and ensuring that intended benefits are enforceable. With these key ideas in mind, let's turn to our first case, and let's break it down with Klamath Water Users Protective Association versus Patterson. It's a case that shows how courts handle third-party beneficiary claims, particularly in government contracts. So here's what happened. The U.S. Bureau of Reclamation entered into a contract with a private company, PacifiCorp, to manage the Link River Dam in Oregon. The dam's operations had a direct impact on water rights in the Klamath Basin, where farmers depended on a consistent water supply for irrigation. The farmers, represented by the Klamath Water Users Protective Association, urged that they were third-party beneficiaries of the contract between the U.S. Bureau of Reclamation and PacifiCorp. When PacifiCorp's operations led to reduced water availability for irrigation, the farmers sued, and they claimed there was a breach of contract that they could enforce because the contract between the U.S. Bureau of Reclamation and PacifiCorp, right? Again, the farmers are not a party to that contract, but this contract obligated the company to manage the dam in a way that protected the farmers' water rights. The key question for the court was this: were the farmers intended beneficiaries of the contract, or were they merely incidental beneficiaries? The court held that the farmers were not intended beneficiaries. They were merely incidental beneficiaries. Why? Because there was no clear evidence that the Bureau and PacifiCorp entered into the contract with the intent to confer enforceable rights for the farmers. So let's unpack that a little bit. First, the contract did not include any language explicitly identifying the farmers, or for that matter, anyone else in the Klamath Basin as intended beneficiaries. Courts are reluctant to imply intent when the contract is silent on the point. Second, the purpose of the contract was to define PacifiCorp's responsibilities in managing a dam vis-a-vis the U.S. Bureau of Reclamation. not to guarantee water delivery or availability to specific groups or classes of people. While farmers clearly benefited from the water management resulting from the dam's operation, their benefit was indirect and incidental. The court was focused on the operational relationship between the Bureau and PacifiCorp because the contract was focused on the operational relationship, not on third parties like the farmers. Finally, the court emphasized this was a government contract, and in general, courts are cautious about binding third-party beneficiary rights in public agreements unless the intent is crystal clear. Hey, governments involve public services all the time. What government contract doesn't benefit the people? Not a very good one, right? So that doesn't mean that everyone who's affected by an agreement can enforce it, or contract law wouldn't have its meaning. So what's the takeaway? Klamath highlights the strict standard courts apply when determining third-party beneficiary status. Even if a third party derives a significant benefit from a contract, they can't enforce it unless the contracting parties intended to confer that benefit in an enforceable way. This case is a reminder of how crucial contract language is. If you want to create enforceable third-party rights or avoid them, you should make your intent explicit. Courts generally don't infer third-party rights lightly, especially in public contracts with huge groups of people affected by them. Now that we've seen how third-party beneficiary claims can fail when intent isn't clear, let's shift gears. Let's explore a what-if scenario to test these principles in different contexts. Imagine this. A company called BuildCorp signs a contract with EquipTech, a supplier, to purchase custom machinery for new building projects. The contract specifies that the equipment must be compatible with software provided by Soft Systems, a third-party software vendor. The compatibility requirement is crucial because Soft Systems software controls the machinery's performance, and BuildCorp has already invested heavily in integrating it across all their building operations. Now let's say EquipTech delivers the machinery, but it doesn't work properly with SoftTech software, which causes delays and costly downtime for BuildCorp, and creates liabilities for Soft Systems, who has obligations in the contract regarding uptime and downtime for its client, BuildCorp. Seeing the disruption, Soft Systems decides to sue EquipTech, arguing it's an intended third-party beneficiary of the contract between BuildCorp and EquipTech. So here's your first question. Does the compatibility clause in the contract between BuildCorp and EquipTech indicate that Soft Systems is an intended beneficiary? The short answer is probably no. While the contract mentions Soft Systems software, that alone isn't enough to prove intent to create enforceable rights for Soft Systems. The compatibility clause likely reflects BuildCorp's needs. Ensuring that the machinery works with their software, if already adopted, gives them a right to sue if it doesn't. It's not really intended to benefit Soft Systems directly, at least not on its language. Courts generally require clear evidence that both parties to the contract intended to create enforceable rights for third parties. Here, the primary purpose of the agreement seems to be delivering machinery from EquipTech to BuildCorp. The benefit to Soft Systems is likely incidental. But what if EquipTech actually knew that the entire success of BuildCorp's projects depended on Soft Systems software working seamlessly with EquipTech equipment? Does that change the analysis? Does it suggest an intention to benefit Soft Systems? Or are we again simply reflecting the practical needs of BuildCorp's projects? This is a little trickier because there is an argument that there are enforceable rights if EquipTech actually knew that Soft Systems had some kind of liability if interoperability didn't work. Potentially some reputational harm that could result for them. But we haven't really changed the scenario enough because third-party rights are so hard to grant. The scenario highlights some of the challenges in distinguishing between intended and incidental beneficiaries. And it reminds us that it's very hard to draw a sharp line between the two. So contracts will generally need to be very, very clear, or courts will hold to the rule of privity, refusing to give third parties rights to enforce contracts they didn't proverbially sign. Let's break it down again with another case that shows another dimension. Let's break it down with Sovereign Bank with BJ's Wholesale Club. This is a case that brings third-party beneficiary law into the modern world of data security and commercial networks, and it relates to our what if. Here's the setup. Sovereign Bank was a credit card issuer that got hit hard after a data breach at BJ's Wholesale Club. The breach exposed customers' credit card information, and that led to fraudulent charges. Sovereign Bank ended up footing the bill for these charges because, under Visa's network rules, the issuing bank is responsible for reimbursing customers when fraud occurs. Sovereign Bank sued BJ's and BJ's payment processor, Fifth Third Bank, arguing that Sovereign Bank was an intended third-party beneficiary of the agreement between BJ's and the bank. The agreement required BJ's to comply with Visa's security standards for protecting cardholder data, and the claim was that BJ's didn't do it. Sovereign claimed these compliance standards existed specifically to benefit issuing banks like itself, making it an intended beneficiary of the contract between BJ's and Fifth Third Bank. The big question for the court was this: did BJ's and Fifth Third intend to confer enforceable rights on Sovereign Bank as part of their agreement? The court's answer? Not so fast. Because while issuing banks like Sovereign clearly benefit from Visa security rules, where's the evidence that BJ's and Fifth Third intended to make Sovereign an enforceable beneficiary of their contract? I mean, Sovereign is a competitor with Fifth Third after all. Let's break down the court's reasoning. First, the court noted that under Pennsylvania law, both parties to a contract must clearly express their intent to benefit a third party. And in this case, the member agreement between BJ's and Fifth Third did not expressly identify Sovereign or any other issuing banks as intended beneficiaries. Second, the court considered the broader context of the agreement. It acknowledged that the security requirements were designed to protect cardholder data, which indirectly benefited issuing banks by reducing fraud exposure. But indirect benefits alone aren't enough to establish third-party beneficiary status. Lots of people could potentially benefit by protecting cardholder data. The benefit has to be a central purpose of the contract. The agreement here seemed more focused on BJ's compliance with Visa's rules than on directly benefiting issuing banks. The purpose of this clause was to benefit Fifth Third Bank. Finally, the court recognized the complexity of the Visa network. There are so many parties involved: merchants, acquirers, issuers, and customers, so it's challenging to pinpoint which parties the contract is intended to directly benefit. The court allowed the issue to proceed to trial, but it recognized that further evidence was necessary to resolve whether Sovereign Bank was in fact an intended beneficiary of the contract between BJ's and Fifth Third. So, what's the key takeaway from Sovereign Bank versus BJ's? This case highlights the challenges of providing third-party beneficiary status in complex commercial agreements. Courts look for clear intent to confer enforceable rights, and they're often cautious about extending those rights in multi-layered relationships like the Visa network. But we also have a broader question here. When contracts involve large interconnected systems, should courts take a more practical approach to third-party beneficiaries? If the primary purpose of security rules is to protect issuing banks from fraud, shouldn't they have enforceable rights? The case forces us to think critically about intent contract language, and the practical realities of modern commerce. It's a great example of how third-party beneficiary law, especially with our Fifth Third Bank, remains relevant in today's interconnected world. Let's shift gears and look at pop culture, because it illustrates the principles of third-party beneficiary law. You may have heard of legal battles surrounding Taylor Swift and her former recording label, Big Machine Records. It's a conflict that's brought to light some important issues around ownership, rights, and who gets to benefit from a contract. In 2019, Scooter Braun's company, Ithaca Holdings, acquired Big Machine Records, which meant that it gained control over Taylor Swift's master recording of her first 6 albums. These masters are crucial because they represent the original recording of her music. And ownership of these recordings determines who earns revenue from things like royalties from streaming and licensing. Taylor Swift, who had been trying to buy back her masters, was furious. She accused Braun of bullying and manipulation. She said she was unfairly denied the opportunity to buy the rights to her own music. This led to a public feud, and ultimately, Swift decided to re-record her old albums. She did this to retain and regain control of her content and her masters, and she began releasing them as Taylor's versions, starting with the album Fearless in 2021. So let's connect this back to third-party beneficiary concepts we've been discussing, because it's where it gets interesting from a contract law perspective. See, Taylor Swift wasn't a direct party to the contract between Big Machine Records and Scooter Braun, but she was profoundly impacted by it. Her ability to control and profit from her own music was essentially determined by terms of someone else's contract. So, could Taylor Swift argue that she's an intended third-party beneficiary of the deal between Big Machine Records and Scooter Braun? Well, she wasn't specifically named in the contract. The deal did affect her financial interests and clearly impacted her artistic control. In theory, there's a question here. Was Taylor Swift a donee beneficiary, someone who was intended to benefit from the deal as a gift? Or was she an incidental beneficiary, someone who just happened to be affected by the sale without any intention of benefiting from it? What about the fans? At least one of you listening to this is a Swiftie. Fans certainly benefit from Swift's music being available on streaming platforms. You might be considered an incidental beneficiary as well. Can you sue for this contract? If Scooter Braun decides to take Taylor's music off Spotify, do you have rights? You probably weren't the intended beneficiary of the Big Machine Records Scooter Braun contract, and the situation highlights a key aspect of third-party beneficiary law: intent. For Swifts or Swifties to claim enforceable rights, the contract would have to show that Big Machine and Scooter Braun intended to benefit directly Taylor or Taylor's fans. And that wasn't the case. It's also a reminder that in many industries, contracts have far-reaching effects beyond the people who just signed them. In the end, Taylor Swift's re-recording project isn't just about taking control of music and creativity. It's a strategic move to bypass a contract that left an artist in a vulnerable position that contract law doesn't address. Her case underscores why it's important to understand how third-party beneficiary rights work and how a contract's intent shapes who benefits from it. As we wrap up today's episode, let's take a moment to revisit key points we've covered about third-party beneficiaries and their role in contract law. First, we explore the doctrine of privity, which generally limits the rights and obligations of a contract to the parties who signed it. But as we've seen, third-party beneficiaries are an important exception to the rule. If the contracting parties intend to confer a benefit on someone who isn't a party to the contract, that third party may be able to enforce it. We also distinguish between two types of third-party beneficiaries: intended beneficiaries, who can enforce a contract because the parties explicitly intended to benefit them, and incidental beneficiaries, who may benefit from the contract but can't enforce it because the benefit was incidental rather than intentional. We discuss how courts determine intent by looking at contract language, by looking at the circumstances surrounding the agreement, by looking at the relationship between the parties. Courts are very hesitant to expand enforcement to third parties, so they require clear evidence that the contracting parties actually intended to benefit the third party in a way that would justify the third party's enforcement of the contract. Finally, we explored how third-party beneficiaries show up in pop culture. While Swift wasn't a direct beneficiary to the contract between Big Machine and Scooter Braun, her case highlights how third-party rights can get complicated, especially when a contract impacts someone's financial and personal interests. The big takeaway? Third-party beneficiary law is crucial not only for interpreting contracts, but also for recognizing who has the right to enforce them. This is especially important in complex contracts where multiple parties and interests are at play. As we wrap up the final episode of this season on mastering contracts, I want to take a moment to thank you for joining me on this journey through this fascinating world of contract law. Whether you're a law student, a professional, or just someone interested in the intricacies of legal principles, I hope you found each of these discussions insightful and engaging. As we close out this episode, I hope you reflect on the concepts we covered in third-party beneficiary rights. If you're gearing up for exams, I'd recommend you keep practicing hypotheticals based on what we discussed throughout the season, because the more you engage with concepts, the more you realize you don't know and the more you can learn, and that makes you better prepared to apply what you've learned into real-world situations. And for everyone, as you move forward, I hope you remember that contracts aren't just about business. They have far-reaching impacts on people that you might not even realize. Understanding these legal principles can help you navigate the complexities of your professional and personal life with more confidence. If you've enjoyed the season, please subscribe to the Organized Podcast and leave a review. Your support helps me continue to break down complex legal topics in an accessible way for students, professionals, and curious minds alike. And at this stage, I'd love to hear what you'd like to see next season. I'm so grateful that you came with me throughout this season, and I hope to see you back for more, where we'll continue exploring the world of contracts, business law, and much more. But until then, keep your agreements strong and your arguments stronger.